Welcome and thank you for standing by. At this time, all participants are in a listen-only mode. During the question-and-answer session, please press star 1 on your touch-tone phone if you'd like to ask a question. Today's conference is being recorded. If you have any objections, you may disconnect at this time. I'd like to turn you over to Mr. Phil Ashmore. Sir, you may begin.
Good afternoon and good morning, everyone. Welcome to Module 9 of the webinar series on international case processing under UIFSA 2008. Presenting today, we have me, Phil Ashmore, along with Ann Miller and Meg Haynes. And there will be time for questions on the phone later on, and if you're on the WebEx, you can type any questions as we go along in the Q&A box. Some people in the audience may have attended multiple conference presentations where speakers have explained the background of the convention or presented an overview of UIFSA 2008. For others, this information will be brand new. The webinar content has been designed to cover both audiences. The webinar resources include the PowerPoint presentation with notes for the slides and a set of trainer notes that provide supplemental information. The resources related to a particular module are available on OCSE's website. The first two modules of the webinar series were overview modules. They provided background information about the 2007 Hague Child Support Convention, so you can better understand the US's goals during the treaty negotiations, and also the process used for negotiating an international treaty and the terminology in the convention. They also discuss the scope of the convention and services that a central authority must provide, so you'll have a better idea of what to expect on outgoing cases to a convention country. Beginning with Module 3, the focus shifted to case processing. The most likely application under the convention is an application to recognize and enforce a support order issued by a convention country. And for that reason, there's one module explaining the process and forms for incoming applications, and a separate module, Module 4, explaining the process and forms for outgoing applications. Module 5 examines incoming and outgoing applications for establishment of a support order, including establishment of parentage when necessary to obtain support. Module 6 examined incoming applications for modification, and Module 7 looked at outgoing applications for modification. Module 8 addressed implementation issues and questions that have arisen, and then finally in this module, Module 9, we will discuss processing international support cases from foreign reciprocating countries that are not convention countries, as well as cases from other foreign nations. So today we're presenting Module 9 to discuss processing international cases that are not convention cases. This slide highlights the topics we will cover today. We have the definition of a foreign country, UIFSA Section 307, incoming and outgoing actions, OCSE's resources for working with foreign reciprocating countries, incoming and outgoing actions with other nations, and UIFSA's evidentiary provisions. And with that, I will hand you over to Anne.
Thank you. UIFSA 2008 contains a definition for state and a separate definition for foreign country. The definition of foreign country includes many, but not all foreign nations. It includes countries in which the Hague Child Support Convention is enforced, and we call these convention or treaty countries. It includes countries that the U.S. has a federal bilateral arrangement with, according to Section 459A of the Social Security Act, and these are called foreign reciprocating countries, or FRCs. It also includes countries with which your state has a state-level reciprocal arrangement. And it includes countries with laws substantially similar to UIFSA. As noted in a UIFSA comment, this category can't be as easily determined as the other three. Theoretically, a tribunal could determine a country has substantially similar laws in a particular case. The comment also mentions the possibility of a state creating an efficient method for identifying foreign countries whose laws are substantially similar to UIFSA. Finally, note that in defining a foreign country, the word country includes a political subdivision of that country. For example, some states have state reciprocal arrangements with the Canadian province of Quebec or with specific states in Mexico. As of October 1st, 2017, the Hague Child Support Convention is in force in 35 countries and includes all European Union countries with the exception of Denmark. It will also go into effect with Brazil on November 1st, 2017. In 1996, Congress passed the Personal Responsibility and Work Opportunity Reconciliation Act. This federal legislation contained major reforms to child support. One of its provisions authorized the State Department, with the concurrence of HHS, to declare a country as a foreign reciprocating country if it met certain requirements. This was the first time there was legislation authorizing federal bilateral agreements. The statute allows a declaration to be made in the form of an international agreement, in connection with an international agreement, or a corresponding foreign declaration, or on a unilateral basis. Most of the current FRC arrangements were made in the form of simple declarations. In order for the U.S. to establish a country as a foreign reciprocating country under federal law, that country must have in effect procedures available to U.S. residents for the establishment of paternity, the establishment of support orders for children and custodial parents, and the enforcement of those support orders, including procedures for collection and distribution. And these procedures must be available to U.S. residents at no cost. The key players in negotiating a bilateral arrangement are the State Department and the Department of Health and Human Services. The Secretary of HHS, in turn, has designated the Federal Office of Child Support Enforcement, or OCSE, to help negotiate bilateral arrangements. Within the State Department, the Private International Law Office negotiates bilateral arrangements. That office is assisted not only by OCSE, but also by a number of subject matter experts. In order for there to be a declaration of reciprocity, the Secretary of HHS must concur with the declaration. Now, in the U.S., the central authority for international child support treaties and bilateral arrangements is the Secretary of HHS. The Secretary has designated OCSE as the entity to serve as the central authority. For foreign reciprocating countries, one of the services OCSE provides is locate assistance. OCSE uses the Federal Parent Locator Service, or FPLS, to assist foreign reciprocating countries when they do not know the U.S. state in which the creditor or debtor resides. However, the information OCSE returns to the FRC is the state of residence. We are not allowed to provide residential or employment address information. OCSE provides policy guidance, tools such as caseworkers' guides, and training to both state child support workers and FRCs. In addition, OCSE responds to numerous inquiries from parents, state child support agencies, and foreign governments, and works closely with federal and state staff on specific case concerns. OCSE is available to provide assistance and coordination in working international child support cases, and our contact information is on the final slide of this presentation. State child support agencies provide the case processing functions in FRC cases. That means requests for child support services in FRC cases are received and transmitted at the state level. State child support agencies are responsible for initiating the appropriate proceedings related to those requests and providing 4D services. The state plan requirement in federal law, as noted on the slide, requires states to treat a request for services from an FRC as if the request is from another U.S. state. Now, this slide lists countries with which we have U.S. bilateral arrangements, but which have not yet joined the Hague Child Support Convention. These jurisdictions include 4 countries: Australia, El Salvador, Israel, and Switzerland, and 12 of the 13 Canadian provinces and territories, all but Quebec. States will work cases with these countries according to the terms of the bilateral arrangement and the country-specific caseworkers guides that OCSC has published. Please note that OCSC is currently revising the guides for Australia and Switzerland. Also, if you have a case with El Salvador, OCSC encourages you to contact the international team for guidance. The next 5 slides provide a bit more detail about each FRC. If you view these slides online, please note that the name of the country is a hyperlink to that country's page on the OCSC website.
So Australia has been an FRC since 2002, and in fact IM 0307 was OCSC's very first caseworker guide. OCSC hopes to have the revised Australia guide out soon, and in the meantime feel free to reach out to the international team at OCSC with any questions. The Australian Central Authority will send cases to the US using our intergovernmental forms, and for outgoing cases, you should use a combination of US intergovernmental forms and the Australian forms. Check the caseworker guide for more information. For most US states, Canada is one of their largest child support partners, and from the perspective of every Canadian province and territory, the United States is their largest international partner. As noted by the slides for the previous bilateral arrangement, the United States and Canada have a long history of working collaboratively. In fact, the Canadian Interjurisdictional Support Orders Act, or ISO Act, was informed by the US experience with UIFSA and allowed Canada to move away from its previous practice of provisional and confirming orders. The Canadian support officers will send cases to the US using our intergovernmental forms, and for outgoing cases you can send either the US intergovernmental forms or the applicable Canadian forms. They'll accept either. Note that in enforcement and modification cases, Canada needs 3 certified copies of the existing US order. Check the caseworker's guide for more information. El Salvador has been an FRC since 2006, and its central authority is very strict about communication in Spanish. El Salvador's central authority will send cases to the US using specific bilingual English-Spanish forms found in the caseworker's guide. For outgoing cases, you must use the same bilingual English-Spanish pleadings, including a limited power of attorney form. Note that the content on all other forms must be in Spanish. US documents in English must therefore be accompanied by copies in Spanish, and all communication with the central authority must also be in Spanish. Before you incur the expense of translations, OCSC asks that you contact our international team for assistance if you have a case with El Salvador. Israel has been an FRC since 2009. The Israeli Central Authority will send cases to the US using bilingual English-Hebrew forms that are in the caseworker's guide. For outgoing cases, the content in the pleadings and other forms must be in Hebrew. The US court order must be accompanied with a complete or partial, in some cases, translation into English. Sending a case to Israel is a 2-step process for the US petitioner. The first step is completing and transmitting the application package to Israel, which will include completing a general power of attorney authorizing Israel's central authority to open a case and act on the applicant's behalf. The attorney appointed to the case in Israel will use this information to prepare a detailed free-form petition, setting out the legal and factual assertions to support the application. As a second step, the U.S. petitioner is required to review and attest to the petition's accuracy via an affidavit of details before the petition may be filed in an Israeli family court. The petitioner must also execute a specific power of attorney allowing the appointed lawyer to act on his or her behalf and a uniform family court form. These documents will be sent directly to the U.S. petitioner by the appointed attorney unless the 4D agency specifically states that this procedure is not acceptable. Switzerland has been an FRC since 2004. Keep in mind that Switzerland is not part of the European Union and it has not ratified the Hague Child Support Convention. Also be aware that Switzerland's language requirements are not uniform. Switzerland is divided into local cantons, which may have any of German, French, or Italian as their official language. The Swiss Central Authority may send cases to the US using multilingual forms found in the Caseworker Guide, and for outgoing cases, child support agencies must use these multilingual Swiss forms, which include an application and power of attorney. The content of the forms must be in the official language of the particular Swiss canton. Depending on the canton, that could be French, German, or Italian, and the US documents must also be accompanied by a translation into the official language of the Swiss canton. OCSC is developing an updated Caseworker's Guide for Switzerland. And over to Anne.
Thank you. Federal bilateral arrangements take precedence over any state reciprocal arrangement. However, Section 459A of the Act permits states to enter into reciprocal arrangements with countries that are not the subject of a federal declaration. At the state level, this is implemented through Section 308B of UIFSA. A similar position was in the revised Uniform Reciprocal Enforcement of Support Act, the 1968 precursor to UIFSA. Michelle, I don't think that's the right slide. Go back to 20. Oh. Excuse me, just a minute. Okay. UIFSA's definition of foreign country includes a country with which your state has a state reciprocal arrangement. States vary regarding the existence of such arrangements. This slide notes countries which are not convention countries or FRCs that have state reciprocal arrangements with one or more U.S. states, the District of Columbia, Puerto Rico, the Virgin Islands, or Guam. Since these are not federal-level arrangements, OCSC does not maintain information about them on its website. However, states list state reciprocal arrangements in response to a question on the Intergovernmental Reference Guide, or IRG, which is available on OCSC's website. At the state level, the State Child Support Office or Secretary of State usually maintains such information. Now we're going to discuss UIFSA Section 307 and the significance for international cases. When a state legislature enacted UIFSA 2008, it could choose between Alternative A and Alternative B of the Model Act. Both alternatives are based on language in the Federal Preventing Sex Trafficking and Strengthening Families Act that Congress passed in 2014. Now, if your state enacted Alternative A, you as the support enforcement agency must provide services in a proceeding under UIFSA to all petitioners regardless of where they reside. That includes direct applications for services in a UIFSA proceeding received from petitioners living in other countries, regardless of whether the country meets the definition of foreign country under UIFSA. Now, if your state enacted Alternative B, you as the support enforcement agency must provide services in a UIFSA proceeding to a petitioner who resides in a state as defined by UIFSA. You must also provide services to a petitioner who requests services through a central authority. That central authority may be in a Hague Convention country or in a foreign reciprocating country. However, under Alternative B, if you receive a direct application for services in a UIFSA proceeding from a petitioner who lives in a foreign nation that is not a convention country or an FRC, your state has discretion about providing such services. Similarly, your state may, but is not required to, provide services in a UIFSA proceeding to a petitioner who lives in a Hague Convention country or an FRC and applies directly for services in a UIFSA proceeding rather than going through his or her central authority. Keep in mind that UIFSA covers all interjurisdictional child support cases, 4D and non-4D, and that applications for 4D services are made pursuant to Title 4D and federal regulations, not UIFSA. One of the unique provisions of UIFSA 2008 is Section 105, which provides a clear roadmap to tribunals that are handling an international case. The tribunal must apply UIFSA Articles 1 through 6 to a support proceeding involving an order issued by a foreign country, a tribunal of a foreign country, or a party or child residing in a foreign country. Keep in mind, the provision is referring to a country that meets UIFSA's definition of a foreign country, and that definition includes an FRC. If it is a convention proceeding, the tribunal must apply the new Article 7 of UIFSA. So long as there's no conflict with Article 7, the tribunal will also apply Articles 1 through 6. Keep in mind that Article 7 applies only to applications under the Hague Child Support Convention. If a tribunal is recognizing an order on the basis of comity, which is a case-by-case decision, the tribunal may apply UIFSA Articles 1 through 6. It's not mandatory to use UIFSA in such cases. Comity is a legal term, and it's a willingness by the U.S. tribunal to recognize an order based on respect for the foreign tribunal because it complied with our concept of due process. The recognition is not as a matter of legal requirement. Because comity is extended to an order, not a country, the next time a different order from that country comes before the tribunal in a different case, the court must decide anew whether to recognize the second order on the basis of comity. Now that we've discussed the types of international cases, how do we approach case processing? This slide offers some broad steps for approaching international case processing. When analyzing an incoming case, you need first to determine whether the country sending the case meets UIFSA's definition of foreign country. Is it coming from a convention country? If not, is it coming from an FRC or a country with state-level reciprocity? You also need to determine whether the applicant applied through the central authority where he or she lives, or whether the applicant filed directly with the agency. UIFSA Section 307A comes into play then. In addition, you will follow the UIFSA roadmap regarding which provisions of UIFSA apply. Now, for outgoing cases, you need to determine whether you are sending the case to a convention or a foreign reciprocating country, and the answer will affect the forms you use for the case. Don't forget to check available resources, such as the Caseworker's Guides on OCSC's website. As we all know, these can be hard and complex cases for families and for caseworkers, so please ask for help if needed. OCSC's international team and members of the NCIA International Committee are among those who are happy to share information.
Now let's look at a couple of case scenarios to illustrate the importance of the applicant's place of residence. In the first scenario, the custodial parent lives in Ontario, Canada, and the non-custodial parent lives in and works in Michigan. The custodial parent wants Michigan to recognize and enforce a Canadian order. How should she proceed?
Well, because Ontario is not a Hague Convention country, she cannot file an application under the convention.
So what is her recourse?
According to the international page of OCSC's website, Ontario, Canada is a foreign reciprocating country with the U.S. It therefore meets the UIFSA definition of foreign country. as long as she applies through the Ontario Child Support Agency, the Michigan Support Enforcement Agency must provide services in the UIFSA proceeding, regardless of whether the state has enacted Alternative A or B of Section 307.
And which provisions of UIFSA will apply?
According to the roadmap in Section 105, the tribunal should apply Articles 1 through 6 of UIFSA.
In this second scenario, the custodial parent lives in Switzerland. The non-custodial parent lives and works in Michigan, and the custodial parent wants Michigan to recognize and enforce a support order issued by France. How should she proceed?
Under Article 10 of the Hague Child Support Convention, one of the threshold criteria for an applicant to seek the assistance of a central authority under the convention is that the applicant must reside in the requesting contracting state. In the example depicted on this slide, the custodial parent has an order issued by France, which is a convention country. However, because she resides in Switzerland, which is not a convention country, she cannot file an application under the convention.
So what is her recourse?
According to the international page of OCSC's website, Switzerland is a foreign reciprocating country with the U.S. and therefore meets the UIFSA definition of foreign country. Similar to the first scenario, as long as she applies through the Swiss Central Authority, the Michigan Support Enforcement Agency must provide services in this proceeding, regardless of whether the state has enacted Alternative A or B of 307.
And what provisions of UIFSA will apply?
According to the UIFSA's roadmap, the tribunal should apply Articles 1 through 6 of UIFSA. And what?
Thanks, Anne. Now that we've provided an overview of processing cases from an FRC, let's drill down and look more closely at specific requests in an incoming case. OCSC issued a Dear Colleague letter in 2011 regarding forms in international cases. It pointed out that there's no federal requirement that foreign reciprocating countries use the federal forms mandated for 4D cases, nor is there a state requirement within UIFSA. Rather, UIFSA requires that the petitioner submit a petition and accompanying documents that conform substantially with the requirements imposed by federal intergovernmental support forms. OCSC encourages states to be as flexible as possible when you're processing cases from FRCs and to interpret UIFSA's substantial conformance provision broadly. Given the importance of uniform forms for efficient case processing, OCSC has worked with FRCs to reach consensus on forms to be used under the respective reciprocity agreement or declaration. And if these forms are available, the alternative forms are included in a country's chapter in a caseworker's guide to processing cases with foreign reciprocating countries. One very important principle in case processing is to continue to process an international application, whether it's from an FRC or a convention country, as much as possible, even if it's not on the applicable intergovernmental or Hague Convention form, or even if it's not as complete as you'd like it to be. Keep in mind that federal regulations direct states to process cases to the extent possible pending receipt of any missing documentation. Now, obviously, these cases are different from your interstate cases, so they're going to require extra effort and understanding. On an incoming establishment case, the FRC may be sending you a petition and testimony using the federal intergovernmental forms, or they may be using other agreed-upon forms. If the caseworker guide for a particular FRC indicates agreement on certain forms and those forms haven't been used, please remind the requesting central authority of the agreement. If there are not any agreed-upon forms, please be flexible in working the case. Let the requesting central authority know what forms or documents are needed and in the meantime, process the case to the extent possible while you're waiting for receipt of the missing documentation. According to the UIFSA roadmap, you'll process an incoming establishment case from an FRC similarly to how you process an incoming interstate case. In an establishment case, it will be your state's law as the forum state that will apply both in determining the support duty and in establishing the support amount. And once the support order is issued, it's going to be your state's law that governs duration of support. On an incoming modification case, the FRC may send a petition and testimony as well as the letter of transmittal requesting registration using the federal intergovernmental forms or other agreed-upon forms. And as previously noted, if the caseworker's guide for a particular FRC indicates agreement on certain forms and those forms haven't been used, just remind the requesting central authority of that agreement. If there are no agreed-upon forms, please be flexible in working the case. Let the requesting central authority know what forms or documents are needed, and in the meantime, process the case to the extent possible. According to the UIFSA roadmap, you'll process an incoming modification case from an FRC similarly to how you process an incoming interstate case. There's one exception. Ordinarily, UIFSA provides that if a tribunal has continuing exclusive jurisdiction, what we call CEJ, no other state can modify the order. However, under Section 615 of UIFSA, even if the issuing country has CEJ, if the foreign country lacks or refuses to exercise jurisdiction to modify under its laws, a U.S. tribunal may assume jurisdiction to modify. Consent by the parties to modify the order in the U.S. isn't required, and the petitioner may reside in either the responding state or the foreign country. How are you going to know if the foreign country lacks or refuses to exercise jurisdiction to modify? Well, that's going to be a case-specific determination. The example provided by the official comment to UIFSA is when an obligor has moved to the responding U.S. state and the law of the issuing country requires the physical presence of both parties at a hearing in order to modify its order. The comment further notes that there may be a reason for the foreign tribunal to refuse to modify its order. So a state tribunal should be circumspect when modifying another country's order under this provision of UIFSA. The comment encourages tribunals to communicate with each other under Section 317 rather than relying on representations of either of the parties. In a modification case, it will be your state's law as the forum state that will apply both in determining the availability of modification and in establishing the support amount. One question that's come up is whether a state tribunal can modify the duration of support in a foreign order. If the order was issued by another U.S. state, Section 611 of UIFSA is clear. It prohibits the tribunal from modifying any aspect of this child support order that may not be modified under the law of the issuing state, and that includes the duration of the obligation of support. Because Section 611 is specific to state support orders, the comment to UIFSA in Section 616 provides that presumably the general law of a state regarding modification of a child support will apply to modification of a foreign support order. Keep in mind that any foreign order a U.S. tribunal modifies may, in some instances, have to be later recognized in the original issuing country. So for that reason, a U.S. tribunal may decide it will only modify terms that a tribunal in the issuing country would modify. With regard to enforcement, UIFSA 2008 has an important change. Section 501, which authorizes direct income withholding, is limited to income withholding orders issued in another state. Because of the new definition of state, this provision no longer applies to foreign support orders. So employers are not required to honor direct income withholding orders from foreign countries. On the other hand, Section 507 UIFSA authorizes a state to use administrative enforcement of a foreign support order. Also, an FRC may decide to register a foreign support order for enforcement under Article 6 of UIFSA. The documents, timeframes, and available defenses are the same as those applicable to registration for enforcement of a state order.
Child support caseworkers have raised questions about cases already being handled at the time of UIFSA 2008 coming into effect in their state, or the Hague Child Support Convention coming effective in the US. So let's review some of those questions. Before UIFSA 2008 came into effect, the employer was honoring a direct income withholding based on a foreign income withholding order. Now that UIFSA 2008 is in effect, must the employer continue to honor the direct foreign income withholding order?
The answer is no. The employer may continue to honor such orders if it chooses. However, as Meg just mentioned, now that UIFSA 2008 is in effect, an employer is not required to honor the direct foreign income withholding order. If an employer decides not to honor a direct income withholding order issued by a foreign country, UIFSA provides procedures for the FRC or convention country to register the foreign support order in a state for the purpose of enforcement. In such a case, OCSC encourages the employer to discuss options for managing income withholding with the state child support agency and the foreign child support office as appropriate, so as not to disrupt the flow of payments to the family.
Now that the Hague Child Support Convention has entered into force in the US, how should states handle cases that are currently being worked under a federal bilateral agreement?
States should continue to work cases that were initiated under a bilateral agreement so as not to disrupt payments to families. However, if a major action is needed in a case, such as a modification, and the other country is also a convention country, states should use convention forms and follow convention requirements as provided in Article 7 of UIFSA and the convention. The following FRCs are now convention countries: the Czech Republic, Finland, Hungary, Ireland, Netherlands, Norway, Poland, Portugal, Slovakia, and the United Kingdom. Now I'm going to turn it over to Phil and Meg for some more case scenarios.
So let's apply what we've discussed so far to a case scenario, and let's assume the central authority in Quebec has sent the Florida Central Registry a request to register and enforce a support order issued in Quebec. In the order, the court determines paternity and sets the support amount. The order also requires support to age 21 if the child is attending university and dependent on a custodial parent. Assume also there was proper notice and an opportunity for the obligor to appear. The other relevant facts are that Florida has a state-level reciprocity arrangement with Quebec where the custodial parent resides, and jurisdiction to issue the order was based on the fact that the creditor and child were living in Quebec. Using the case analysis steps we discussed earlier, the Florida Case Registry and local child support office need to answer the following questions. First, does Quebec meet the definition of a foreign country under UIFSA?
Well, Canada has not ratified the Hague Child Support Convention, so Quebec's not a convention jurisdiction, nor is it a foreign reciprocating country under a federal bilateral arrangement, but it is party to a state reciprocal arrangement with Florida, so the answer, Phil, is yes, Quebec is a foreign country under UIFSA.
So the next case processing question is whether the petitioner applied directly to the Florida Child Support Agency for 4D services, or whether the petitioner sought services through the central authority in Quebec. Under the facts of this scenario, the petitioner applied through the central authority in Quebec. How does this impact the next question? Must the Florida Support Enforcement Agency provide services under UIFSA to the petitioner?
If Florida had enacted Alternative A of Section 307A, it must provide services to all petitioners regardless of where they reside. If Florida enacted Alternative B, it must provide services to petitioners who reside in convention countries and FRCs and who apply through those countries' central authorities. But for other countries, the services are discretionary. Florida enacted Alternative A of Section 307A, and that means the support enforcement agency must provide appropriate services to this petitioner.
So which article of UIFSA should Florida use to register the order for enforcement?
Because Canada is not a convention jurisdiction, Article 7 doesn't apply. The Florida agency will use Article 6 of UIFSA to register the Quebec order in Florida for enforcement.
So let's assume the order has been registered for enforcement and notice has been sent to the obligor. Within the 20-day period for challenge, the obligor has contested the registration on the basis that Quebec did not have jurisdiction over him when the order was entered. He also objects to paying support beyond the duration set by Florida law. Are those valid defenses under UIFSA?
Well, lack of personal jurisdiction is a valid defense to recognition and enforcement of a foreign order, and creditor-based jurisdiction does not comply with U.S. due process requirements. So the obligor may have a valid defense to recognition of the order if that was the basis of the court's jurisdiction. Payment of support beyond the age of duration in the responding state is not a valid defense to registration under Section 607. In fact, USS Section 604 provides that the law of the issuing state or foreign country governs the duration of current payments under a registered support order. So it will be Quebec's law, not Florida's, that governs the duration of the obligor's support obligation.
In this scenario, a petitioner has applied directly to the Ohio 4D agency seeking enforcement of an order issued by a court in Kenya. The respondent, who now lives in Ohio, received notice of the proceeding in Kenya and had the opportunity to participate. The other relevant facts are that the child was conceived and born in Kenya, and Ohio does not have a state-level reciprocity arrangement with Kenya. Using the case analysis steps we discussed earlier, what questions do the Ohio Central Registry and Local Office need to answer? First of all, does Kenya meet the definition of a foreign country under UIFSA?
Well, it's not a convention country. It's not a foreign reciprocating country under a federal bilateral arrangement, and it's not a party to a state reciprocal arrangement with Ohio. So the answer is no, Kenya is not a foreign country under UIFSA, unless a tribunal or other appropriate official in Ohio has determined Kenya has laws and procedures for the enforcement of a support order that are substantially similar to UIFSA. The next question is whether the petitioner applied directly to the Ohio Child Support Agency for 4D services or whether the petitioner sought services through a central authority in Kenya. And depending on whether Ohio enacted Alternative A or B of Section 307A of UIFSA, the answer to that question is going to have consequences. Here, Ohio enacted Alternative A, so the agency has to provide services to all UIFSA petitioners, regardless of their residence or whether they apply through a central authority. And finally, the agency needs to decide how to proceed with enforcement. Because Kenya is neither a convention country nor a foreign country under UIFSA, the 4D agency may request the tribunal to recognize and enforce the Kenyan order on the basis of comity. The roadmap in Section 105 of UIFSA provides that in that kind of case, the tribunal may apply the procedural and substantive provisions of Articles 1 through 6 of UIFSA, but it's not required to do so.
Great, thanks, Meg. So now we'll take a pause and take a breath for some questions that we've received on the WebEx and also maybe to open up the lines as well for any phone questions. First of all, the WebEx questions, I'll select a couple of them that we've received. And one is a question about how effective the FPLS can be when the NCP does not have a social security number. That could be a case where the individual is not a U.S. citizen, or he's in the U.S. on some kind of visa, or possibly illegally. And the basic fundamental answer is that usually we need an SSN to locate an individual, but we do know, of course, that the FPLS gathers data about people from multiple different sources, and the FPLS team are often able to identify an SSN without that being presented first of all. So long as you have the name and date of birth of the individual, it is possible for the FPLS team to obtain the SSN. Another question that we have received, just scroll down to these, excuse me. We have a question, do we treat a case coming from one U.S. state to another U.S. state the same as if it was coming from the central authority of a Hague Convention country?
This is a Hague Convention case would be treated differently from an interstate case because, of course, you're using Article 7 of UIFSA and you're using other Hague procedures and forms and rules to process the Hague Convention case.
Okay, great. And operator, can we maybe open up the lines for any questions on the phone?
Thank you. Participants on the phone, if you'd like to ask a question, please press star 1 and record your name. Please make sure your line is unmuted and record your name clearly with the prompt. To withdraw your request, please press star 2. Again, if you'd like to ask a question, please press star 1 and record your name. One moment to see if we have any questions. And I'm showing no questions in the queue at this time.
All right, thank you very much. So we'll move on in the presentation. So let's shift now to outgoing cases to a foreign reciprocating country. Meg.
Thanks, Phil. As noted at the beginning, one of the requirements for a bilateral arrangement is that the country has to have in effect procedures available to U.S. residents for the establishment of paternity, the establishment of support orders for children and custodial parents, and the enforcement of support orders for children and custodial parents, including procedures for collection and distribution. And all of these procedures have to be available to U.S. residents at no cost. In addition, the country must designate a central authority responsible for facilitating support enforcement in cases involving residents of the foreign country and the U.S. residents. And the central authority also ensures compliance with the standards established under the bilateral arrangement. When a child support agency sends a case to an FRC, it's going to be that country's laws and procedures that govern. So that country's laws and procedures will govern jurisdiction to establish and modify an order, the basis for a support obligation, determination of the support amount, such as the application of any support guidelines, the availability of modification, and enforcement of the order. And I'll turn it over to Anne.
Thank you, Meg. As noted earlier, OCSC issued a Dear Colleague letter in 2011 regarding forms in international cases. DCL 1122 addressed not only incoming cases to the U.S., but also outgoing cases from the U.S. to an FRC. The DCL stated that U.S. child support agencies are required to use federal intergovernmental forms for an outgoing case to an FRC, the same as those used in interstate cases, unless specific forms have been provided for that country. But please check the OCSC website for the applicable caseworkers guide before sending a case to an FRC, and do not automatically send the federal intergovernmental forms. El Salvador, for example, will only accept the bilingual forms that are included in the caseworkers guide, and will send the case back if you send any other forms. Besides having bilingual forms acceptable to the FRC, additional forms might be required, such as the power of attorney. OCSC's international page has a number of resources for working with FRCs. The link on the slide is to the landing page for OCSC international information. Follow the link to the current list of FRCs and then click on the link to the particular country. As noted earlier, OCSC has developed caseworkers guides for the 5 foreign reciprocating countries that are not convention countries. Again, Australia, Canada, El Salvador, Israel, and Switzerland. And we are in the process of updating the guides for Australia and Switzerland. The guides are based on extensive discussions with representatives of the FRC Central Authority to ensure the information is accurate and practical. There's information on the FRC in general, its child support program, and the Central Authority there. There may be specific forms, as I mentioned, some bilingual, to use for a case to this country. And sometimes the caseworker guide will also describe what information the U.S. Child Support Agency can expect to receive from the FRC.
Okay, well, we've discussed incoming and outgoing cases with a foreign reciprocating country. What about an incoming action from a foreign nation that does not meet US's definition for foreign country? In other words, talking about an incoming action from a country that's not a convention country, not an FRC, not a country that's party to a reciprocal arrangement with your state, and not a country with laws substantially similar to UIFSA. What forms and procedures apply to those cases? Let's first talk about an incoming establishment and modification case. If your state enacted Alternative A of Section 307A, you as a support enforcement agency must provide appropriate services in a UIFSA proceeding to all petitioners regardless of where they reside. That includes all direct applications for services in a UIFSA proceeding received from petitioners living in foreign nations that do not meet UIFSA's definition of foreign country. For those cases, obviously there are no agreed-upon forms, and you would use forms under your state law. Process the request as you would process a similar request in a domestic case, which means it will be your state's law that governs establishment of a support duty, determination of the support amount, and the availability of modification. On the other hand, if your state enacted Alternative B, and you as a support enforcement agency receive a direct application for services under UIFSA from a petitioner who lives in a foreign nation that's not a Hague Convention country or an FRC, your state has discretion about providing such services. What about a request for enforcement? Well, as just noted, if your state enacted Alternative B, and you as a support enforcement agency receive a direct request for enforcement under UIFSA from a petitioner who lives in a foreign nation that's not a Hague Convention country or an FRC, your state has discretion about providing such services. But if your state enacted Alternative A, you as a support enforcement agency must provide services under UIFSA to all petitioners regardless of where they reside. And that includes all direct requests for enforcement under UIFSA received from petitioners living in foreign nations that do not meet UIFSA's definition of foreign country. For those cases, your state law will determine the forms used. What procedure would be used to recognize the order issued by the foreign nation? Well, Article 6 of UIFSA applies to registration and enforcement of a support order issued by a foreign country, as defined by UIFSA. There's no requirement to apply it to orders issued by other foreign nations. Rather, Section 105B, which is the roadmap we keep referring to, provides that a tribunal may apply principles of comity, if appropriate, to recognize a support order issued by a foreign nation that does not meet the definition of foreign country. And as we've noted earlier, comity is a legal term. It's a willingness by the U.S. tribunal to recognize an order based on respect for the foreign tribunal because it complied with our concept of due process. The recognition is not one that's required as a matter of law. Because comity is extended to an order, not a country, The next time a different order from that country comes before the tribunal in a different case, the court must decide anew whether to recognize the second order on the basis of comity. Section 105B further provides that if the tribunal recognizes an order on the basis of comity, the tribunal may apply the procedural and substantive provisions of UIFSA Articles 1 through 6. However, is not required to do so.
This slide and the next slide review some questions related to cases from foreign nations that are not convention countries or foreign reciprocating countries. One question is, how can a child support agency establish a support order if the non-custodial parent lives in a foreign nation with which the U.S. has no treaty or bilateral arrangement and the country is not a party to a state reciprocal arrangement?
The most effective recourse is to determine a point of contact in the foreign nation and begin a discussion about available services. Unfortunately, in most cases when there is no reciprocity, state child support agencies are unsuccessful in obtaining a support order because the nation will not provide the custodial parent such services on a cost-free basis. The child support agency may need to suggest the custodial parent seek private legal counsel to pursue child support in these cases. The Department of State's website provides information for citizens needing legal counsel in other countries.
And if the non-custodial parent lives in a foreign country that is not a convention country or an FRC, but works for a U.S. company, how can we best enforce our state support order?
If a child support order has already been legally established and the non-custodial parent works for a U.S. employer that has offices in the U.S., it may be possible to use income withholding or other legal remedies by serving the domestic agent of the U.S. employer. You also may be able to enforce the order domestically if the non-custodial parent owns assets in the U.S. If the parent is a U.S. citizen, you may be able to submit the case to the passport denial program.
So let's move to a discussion of evidentiary provisions within UIFSA. UIFSA 2008 includes a definition for the new term outside the state. It means a location in another state or a country other than the United States, whether or not the country is a foreign country. According to the official comment to the section, the phrase is used in UIFSA when the application of the provision is to be as broad as possible. Outside the state means a different U.S. state, a tribe, a foreign country, or a foreign nation that does not meet the definition of foreign country. In other words, anywhere other than the foreign state. Another UIFSA provision that's important in international cases is Section 316. It replaces the requirement that a person swear under oath before a notary in order for information in a document to be admissible into evidence. Section 316 provides that an affidavit or document, which would not be excluded under the hearsay rule if given in person, is admissible in evidence if given under penalty of perjury by a party or witness residing outside the state. Section 316 encourages tribunals and parties to take advantage of modern methods of communication. So it authorizes the transmission of documents from outside the state by telephone, telecopier, or other electronic means. And finally, a big change from UIFSA 1996 is the requirement that tribunals must allow a party or a witness residing outside the state to testify by phone, audiovisual means, or other electronic means. It is not discretionary, and we'll talk about this requirement in more detail in a minute. If a non-resident party or witness is testifying by telephone or other electronic means, the tribunal may designate the location from which it wants the person to testify. Section 316F of UIFSA mentions testimony from a tribunal outside the state, but it recognizes that the forum tribunal may designate a different location. UIFSA also requires tribunals to cooperate with each other and designating an appropriate location for the deposition or testimony. Let's assume that there's an incoming action from an FRC to the U.S., and one of the parties wants a telephone hearing or an electronic hearing. This slide in the next lists issues that the Child Support Agency needs to address. If you recall, we talked about these issues in Module 8 in the context of a convention proceeding. First, how must the request be made? Some states have court rules that require the party to make a formal request using a standardized form. For example, New York State has a unified court system, and on its website is a form titled Electronic Testimony Application and Waiver of Personal Appearance. That's the form that the New York Family Court uses for hearings in child support cases. Second, what type of assistance can the 4D agency expect from the requesting central authority in the FRC? That's going to depend on the country. Some countries may inform the applicant about the telephonic hearing, but leave it up to the applicant to arrange for his or her participation. You'll find that some central authorities will facilitate the testimony, including arranging for a location for the testimony, and then other countries may be less receptive. I know some countries have cited concerns over coordination issues, and the two coordination issues they've raised the most are time zones and location. Obviously, tribunals and parties need to be flexible in these international cases and accommodating different time zones. Tribunals also differ regarding the designated location for testimony by the non-resident party. Some tribunals require a formal setting, and that may be the child support office, a courtroom, or a notary's office. And other tribunals may be more flexible, and they may be comfortable designating a person's home, especially if there's a large time differential. Technology is another issue. It's much more accessible these days. Most U.S. courtrooms have speakerphones or computers. Depending on the service provider, some courts, though, may be limited to incoming international telephone calls and not able to place outgoing calls. That may result in a great expense to the non-resident party if the court isn't able to calendar the case for a particular time, especially if it's an international call. If FaceTime or Skype is used, there isn't any cost to the party. Obviously, the non-resident party needs access to the same technology used by the tribunal. And if the person is planning to call from a cell phone rather than a landline, it's really advisable to check the quality of the phone connection in advance. Another issue raised by telephonic and electronic hearings is verification of the testifying party. If testimony is provided by phone, a party or witness before the tribunal can usually identify the voice of the non-resident person. Alternatively, an official outside the state, such as a notary or an agency representative, can view a photo ID and verify the identity of the person. Verification of the person is less problematic if the person is testifying by Skype or FaceTime because those provide a visual image. In some international cases, the tribunal will need to provide interpretation for the person testifying. Most U.S. courts have contracts with private companies or local universities or colleges for interpretation services. If you need those kind of services, make sure you provide advance notice to the court, and also try to learn in advance if there are going to be any dialect issues. Another issue that the tribunal needs to address is how documents will be admitted during the telephonic or electronic hearing. And finally, in the United States, any attorney outside the forum who makes an appearance and participates in the hearing must either be licensed to practice in that forum or admitted through a pro hoc vici process. And this includes attorneys located in foreign countries. Pro hoc vici is a Latin phrase. It means for this turn or for this occasion. And it's a special kind of admission by which a lawyer who has not been admitted to practice in a particular jurisdiction is nevertheless allowed to participate in a particular case being heard in that jurisdiction. States have different requirements regarding the pro hoc vici admission process, so make sure you check those. Section 317 and Section 318 are some other important provisions. Section 317 authorizes a state tribunal to communicate with a tribunal outside the state, and as we've noted previously, outside the state means a tribunal of another state as defined by UIFSA, a foreign country, or even a foreign nation that's not defined as a foreign country under UIFSA. The communication can be about the laws, legal effect of an order, or status of a proceeding. Section 318 authorizes a tribunal to help a tribunal outside the state with the discovery process. And with this, I'll turn it over to Phil.
Thank you, Meg. So we'll take another pause here, a final pause for questions and a couple more questions that we received on the WebEx. One interesting question that we received was about Canada and the fact that Canada has actually signed the Hague Convention. It's signed but not yet ratified. So Canada signed the convention on May 23rd of this year, and it's gone through Canada's parliamentary process. But in order for Canada to ratify the Hague Convention, at least one province or territory must amend its laws to adopt the convention. So there is a Canadian federal provincial work group looking at the process, and when Canada ratifies, it is going to specify which provinces and which territories the convention applies to. So there may be a situation where we have Canada as a ratified party to the convention, but it only applies in certain provinces and territories, and the other provinces and territories continue to use the existing bilateral arrangements for some time until they come along too. And then we have another question. Where do you find information on how to apply currency conversion?
In Module 8, which is on our website, we did a section on currency conversion, and there are several resources in that module. If you go to OCSC's international page under Hague Convention and click Training, you'll see all the modules for this series, 1 through 8, and the one we're giving today will be on within a month. But Module 8 has been uploaded to the website, and there are detailed speaker notes and trainer notes, and I'll specifically draw your attention to slide 64. That's where we give 5 different exchange rate websites that you can use in converting support orders. And there's additional resources as well that I would draw your attention to.
Thanks, Anne. And another question that we have on the WebEx is, can a request from a Hague country be returned if no application is received? And by this I understand there has been some kind of forms received from a Hague Convention country, but the application is not complete. And actually the Hague Convention itself directs agencies not to return applications in those circumstances, but simply to contact the initiating central authority to ask for the missing documents or ask for the missing information in order to complete the application. So that's what you do in that situation. And operator, maybe we can open up the phone lines for any other verbal questions.
Participants, if you'd like to ask a question, please press star 1 and record your name. One moment as questions register. I show no questions in queue.
Thank you very much. So this concludes our webinar series on processing international cases. Please look out for an email with a hyperlink to a brief evaluation form. Some of you may have that already. We're interested in your feedback about the training, and in particular, we'd like to know what you found most useful about the training and how we might improve it in the future, and what additional training you would like to receive on international cases. At any point, please do not hesitate to contact OCSC at the addresses on the slide with questions you may have or feedback on the webinar content. And thank you for attending this webinar. And for those of you on the line who've been with us for the whole series, thank you also for bearing with us as we've made our way through some pretty complex issues, but we made it. Have a great rest of your day.
This concludes today's presentation. Again, thank you for your participation. Speakers, please stand by for the